Welcome to the Wills and Estate Transmission Podcast, brought to you by DeGroots, specialist lawyers in wills and estates.
Hi, I'm Kate Donnan, an associate at DeGroots.
Thanks for that, Kate. So the next question is, what is the role of the executor? And this time we're going to do with a slightly different one, is how long it's taken for grants and what a grant is in different states and different requirements for each state.
Sure. So I think it's important to maybe start with what is a grant, because that does dovetail into the role of the executor. So lawyers will typically talk about a grant of representation, and that's essentially the Supreme Court of the relevant state making an order that a particular person or persons is the one that's entitled to administer the estate. Now, if you have made a will and you've appointed somebody to deal with your affairs after you've passed away, that's typically your executor. So a general rule of thumb is that if you have a will, you will have an executor. However, particularly with, say, homemade wills, people might not know that an executor must be appointed. So you can, in fact, have someone that has made a will but doesn't have an executor. Or your executor might have passed away, they might have lost capacity, or they might simply not want to act in the role because it is quite onerous. However, if you do have a will that doesn't appoint an executor, then you would apply for what's called a grant of probate, which is essentially the court sealing your last will as your last will and saying the person you have named can deal with your estate. If you haven't left a will, or you have a will that doesn't appoint an executor, or the executor cannot act for some reason, then you would typically seek a grant of what's called letters of administration. Now, there's a few different types of those. There's letters of administration with the will annexed. So that would be you had a will, but no executor appointed, or you could have letters of administration on intestacy, which essentially means no will, no executor. So in that instance, your estate is going to be divided in accordance with the rules of whichever state you were domiciled in. So they're slightly different in every state, which I suppose, Tony, is another reason to make sure that you get your will in place. So to sum that up, if you've got a will, you typically have an executor. If you don't have a will, or your will doesn't appoint an executor, you'd be an administrator. So their roles are quite similar. So it depends on what state you're in as to what the first steps are for the executor or administrator. So when you're seeking that grant of representation, whether that's probate or letters of administration, you need different things. For example, in Queensland, you don't need to know all the assets and liabilities of the estate before you seek a grant. In New South Wales, you do have to know all your assets and liabilities before you obtain a grant, and that includes things such as your BSB numbers, your account numbers, shareholdings, number of shares, type of shares. So there's quite a lot of information that executor or administrator needs to find out before they can even apply for a grant. And that is the same position in Victoria too. You do need to disclose the assets and liabilities to the estate. When you're seeking a grant. In terms of timeframes, Queensland's taking about 4 to 6 weeks to issue a grant, is our current understanding. In New South Wales, you're looking at about a minimum of 2 months before a grant is issued. And in Victoria, you're looking at about 2 weeks to get a grant of probate. So it's quite quick down there. It's online. They have an online system. And if you are getting a grant of letters of administration, for example, there is no will, so there's nothing to post to the court. In that instance, people are getting some grants back same day. So it's quite a difference in terms of timeframes across the various jurisdictions in Australia. Once you've then got the grant, it's your obligation to call in the assets, pay the liabilities, and then deal with the estate in accordance with either the terms of the will or the rules of intestacy. So the executor in particular has the obligation to carry out the expressed intentions as quickly as possible and as efficiently as possible. So In New South Wales, we typically have what's called an executor's year, where you would anticipate that the executor can administer the estate fully, which means everybody gets their entitlements, all liabilities are paid within 1 year. Of course, Tony, you'll appreciate that people's affairs are becoming a lot more complex. So you might have litigation that slows things down. You might have years worth of unpaid tax that needs to be dealt with. You might have various related companies and trusts that aren't technically part of the estate administration but do still need to be dealt with. All these things can mean that that executor's year is stretched out. But the really important thing that we find at DeGroots is that communication is key. So most people can be reasonable. So we find where the executor or the administrator communicates with the beneficiaries about what's happening and why it's happening and gives updates and expected timeframes. Where administration goes beyond the year, it's not always an issue. So does that answer your question there, Tony, about timeframes?
Thanks very much, Kate. I really appreciate it. And I just thought of something else.
Sure.
Are executors paid?
Good question, Tony. So executors can be entitled to commission for what is called their pains and troubles. So it can be, as I said, quite an onerous role. An executor can apply to the court for commission. It's important to note, though, that if, say, you and I were brother and sister and we were both executors of our mother's estate, if we were both executors and both beneficiaries, the court's not likely going to give us commission because we're taking half of the estate each. If, however, it's, say, a professional that you appoint, so a solicitor, an accountant, they might have a clause in the will that enables them to charge their professional rate for acting, and they might also seek to obtain commission. Another example of where people might seek commission is if they get no entitlement under the will. But what we often seek to do is, when talking to the client about their estate planning, is find out if they're appointing someone that doesn't get a benefit or a large benefit under the will, we might ask them if they'd like to give them a gift in lieu of commission. The benefit of that, Tony, is that if an executor does seek commission, if they don't get the consent of all the beneficiaries of the estate to getting paid that commission, then they do have to approach the court, and the court has to sign off on the commission. They'll also be required to pass and file accounts, which in New South Wales is a specific form of estate accounts, which is a little bit more involved than the usual accounts that an executor would keep. It's also important to note that if any of the beneficiaries of the estate are minors, so under the age of 18, then you do have to go to the court to apply for commission.
Well, okay. Thanks very much for that, Kate.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.